Hello, students. This is Stephen Richardson from lawschool-essentials.com doing a little slide deck here for the California First Year Law Students Examination, June 2013. Question 3 was a contracts law exam. So I'm going to be reviewing that fact pattern and outlining, and I'm going to do an IRAC too. This is not legal advice, should not be construed as. This is for educational purposes to help students out. Okay, so this is the basic information that you see when you take the exam. These are the instructions. Um, we're going to use products from the lawschool-essentials.com mnemonic memory guides to set up the outline, and you can also find black letter law there to help you memorize that. So again, run, don't walk over to lawschool-essentials.com. Okay, here's the question. You always read the call of the question first. You should immediately be focusing on contract law. Did Barbara enter into an enforceable contract with Sally? So enforceable, that tells me formation and defenses to formation. If Barbara entered into an enforceable contract with Sally, what remedies, if any, does she have? So this kind of tells you it was valid, but it could go either way. And then they just want to know if it is. What remedies would she have? So Sally wanted to sell an antique doll that she had inherited. She posted a photograph of the doll on her Facebook page with a note stating, "Last month, one just like this sold on eBay for 650. I'll sell it to any of you for 450." This is a Facebook post. "First person I hear from gets it. Otherwise, after 5 days, I'll sell it on eBay. Call me. No Facebook allowed at my job." All right. Yeah, so it seems like the offer's okay. They're stipulating how to respond. Um, that same day, Barbara, one of Sally's Facebook friends, the same day, saw Sally's post. Um, she believed that the doll might be worth more than 450. She soon learned from a local antique dealer that it was worth 1,500. She used her tablet computer to go on Sally's Facebook page. There, she saw a note posted by Judy, another Facebook friend of Sally, stating, "The doll is worth way more than you think. Don't sell it." Barbara then left a note stating, "I'll take the doll for 450. Barbara, sounds like an acceptance, right? But it's on Facebook. Later, she called Sally and said, "Hey, this is Barbara. I'll buy the doll for 450." Sally replied, "Sorry, you're too late." Barbara looked again at Facebook and saw a new note from Sally stating, "Thanks for the information, Judy. The doll is going straight to eBay." So you're going to have to map out, this timeline of what's going on and how it's the modality. So, but the first thing, um, this is common law because these people are not merchants. They're not. They don't deal in the kind of goods, right? She's just a person that inherited a doll, and Barbara's her friend. Um, so doesn't look like any problem with the offer except the revocation. Acceptance must mirror the offer in terms of modality. This is what I'm thinking while I'm reading this. Consideration doesn't look like problems here. The doll for money, so that's a bilateral. Defenses to enforcement. None come to mind. Maybe mentioning the statute of frauds writing, but then dismiss it because it's for $450. Statute of frauds is a writing required more than $500. So remedies for Barbara, they must be foreseeable and reasonable. Maybe cover to get the same kind of doll, to find the same kind of doll. Let's say it would cost 1,500, so that cover would be 15 minus 450, 11 or 1,050, or market value less $450. That's speculation, or specific performance, and that might not be the case because the doll's already sold. So we're just gonna have to talk about that. So here we go with the outline. These are outline checklists from my products on lawschool-essentials.com. So it helps to set up, who the parties of the contract are. And in this case, it helps to when the things were said. And you'll see in my answer, you're gonna see that. Okay. Mutual assent, offer made, offer still open, consideration, was the offer accepted? And then the defenses to enforcement. And you're gonna have to look at these and see. And as I'm looking at these, it's not unconscionable, it's not illegal. So there's no public policy problems. Capacity to adults, problems with fraud, duress, or mistake. I don't think Barbara can say mistake, or Sally can say mistake, because she put the price out there, unless she meant to say 4,500 instead of 450. But that's iffy. Statute of frauds, the writing, you can quickly dismiss that. Performance within a year, it's like you burp up the money and they burp up the doll. So it's not a guarantee contract or exceptions or writing for a statute. Stopped maybe, but I don't think so. Okay, so now we move on to the Iraq. So give you 20 minutes for this, because you want to be thorough, right? So you've got to demonstrate to the grader that you know about offer acceptance and consideration, right? So I've got the rule statement that's memorized. You have to be able to just regurgitate this word for word, or as closely as possible. Um, so is there a contract between Barbara and Sally? And so this analysis is going to hinge on the, or this case is going to hinge on the revocation and the acceptance. Was it done properly? Was it done in the required manner? And as I said in the analysis, only a jury will be able to decide this based on instructions from the judge. So there was a Facebook offer, a Facebook acceptance, Facebook revocation, phone acceptance, right? That's how this went down. So offer made by Sally on Facebook, revocable after 5 days. Barbara unequivocally accepted the offer on Facebook the same day. Sally revoked the offer on Facebook. Barbara acceptance made on same day as posting in the same manner as offer was made on Facebook. And Barbara called Sally as a follow up for the acceptance. It was a mirror image in terms of in terms and modality. That's common law explanation there. So the mailbox rule, interesting, states acceptance must be in the prescribed manner. So the prescribed manner was phone call, right? Probably because, well, she can't get Facebook. She can't see the first in, the person who's first in, which you can. I mean, once you get home, you can look on the Facebook and see the timestamp, see where you end up in the replies. So a jury will most likely need to decide this. So in the conclusion, you don't be conclusory. You should say that it appears the jury's going to have to decide this. It appears, however, does it survive defenses to enforcement? That leads you to the following part of your analysis on the contract, the last part. Are there any defenses? In order for a contract to be enforceable, it must withstand certain criteria, or else a contract can be held voidable. And so if Barbara was paying an exorbitant price, unconscionability, but this is not the case. Is the contract in writing? It doesn't need to be. So do not be conclusory, and just say, based on the fact, don't introduce new facts. Based on what you've analyzed, this is the most likely outcome, right? Make your decision, right or wrong. Okay, so now the remedies. So we go over to lawschool-essentials.com, look at the remedies checklist, and it's easy mnemonics to memorize these things. Read it, write it, repeat it over and over and over. So again, they have to be foreseeable and reasonable. Damages are designed to bring the non-breaching party. So if this was a valid contract, right, you can say that, then upon performance, the other person has to perform, right? So if the other person doesn't perform, that's a breach, right? So you could have put the definition of a breach. Well, that's pretty much what I did. Generally, non-breaching party can expect compensatory, consequential reliance, restitutionary, incidental damages, and/or specific performance. And then you could say in the analysis that the best option was be specific performance, but the doll is probably going to be sold after it makes its way to court. So pending that, then it's probably going to be the market value of a similar doll less the cost of what it would cost to buy that other doll. Whatever that market value is, 1,000, 1,400, an expert's going to have to do that. And then you make your conclusion. Again, not conclusory, but what will most likely happen. Okay, if you liked what you saw, click the subscribe button, tell your family, tell your friends, tell your enemies. And I'll be doing more. It's not just first year law student exams. I'll be looking at Cal Bar stuff too. It just takes time to do this and upload it, but I want to help you guys. So I'll see you on the next one.